injured party must prove the elements of negligence. The elements are duty, breach, causation, and damage. Once the elements have been established, the question then shifts to whether the defendant may still avoid liability by asserting a negligence defense. The most common negligence defenses are contributory negligence, comparative negligence, and assumption of the risk. This video will discuss all three defenses, when they're used, and how they're established. Contributory negligence. When an injury occurs, both the defendant and the plaintiff can be at fault. For example, in a car accident between car A and car B, car A's driver was speeding and car B's driver was driving under the influence. Both drivers are engaged in negligent, risk-creating behavior. The negligence on the part of the injured plaintiff is called contributory negligence. A plaintiff contributes to his own injury when his behavior falls below what the reasonable person would have done to protect himself from injury. In other words, contributory negligence requires everyone to take reasonable steps to avoid danger. Traditionally, contributory negligence was a harsh rule. It completely barred a negligent plaintiff from recovering no matter how minor the plaintiff's fault. If a plaintiff had any part to play in his own injury, no matter how minimal, the plaintiff could not recover from the defendant. For example, Timmy leaves the bar from a heavy night of drinking and slams his car into Ronald's car, which is parked illegally on the side of the road. Ronald is injured, files a lawsuit against Timmy. Under contributory negligence, Ronald would not recover from Timmy for Ronald's injuries despite Timmy's drunk driving. Ronald contributed to his own injuries by parking his car illegally and is therefore barred from recovery.
Let's say Perry is carelessly playing a video game as he crosses the street. Here comes David, who is going too fast on his skateboard while listening to music. And David slams into Perry. And we'll say Perry sues David for negligence and wants $100,000.
Hello there, my name is Vicky. Today I'll be a presenter presenting about today's topic, which is contributory negligence. Well, for based on our today's topic, which is contributory negligence, the issue will be whether Harry, as a plaintiff, can sue David as a defendant. As for Section 12 of the Civil Law Act 1986, it's basically where any person suffers damage as the result partially of his own and partly of the fault of any person or persons. A claim in respect of the damage shall not be defeated by reason. As a defendant, based on the court in this case identified two particular acts and omission of the defendant, which is failed to wait until the plaintiff had safely crossed the way and failed to ride slowly or control the skating to avoid colliding into plaintiff. As for the plaintiff, still the court pinpointed the plaintiff was to be liable for contributory negligence under these three particular acts and omission of the plaintiff, which is failed to observe the defendant which reasonable in time order to avoid accident, failed to take care of himself when he was on the road, and failure to assess the risk although he knew the danger that would be created by his act. Anyways, moving on to the next section, which is contributory negligence cases that related to this case, which we have two scenarios. Well, the first scenario, which is John V. Levox queries, basically explains the plaintiff had ridden on the back of a vehicle which known as excavator, thereby exposing himself to the risk that he might be thrown off and injured. The second scenario, which involves Mr. Ramachandran, basically explains that the plaintiff suffered injuries in an accident which allegedly took place when he was in the employment of the second defendant. Finally, we have concluded in this case, David, the defendant, is 99% responsible for that accident, but Harry, the plaintiff, is 1% responsible too. So, the court concludes that plaintiff is not liable for compensation from his defendant because plaintiff's actions are not reasonable in the circumstances due to his own negligence.
Let's say Perry is carelessly playing a video game as he crosses the street. Here comes David, who is going too fast on his skateboard while listening to music. And David slams into Perry. And we'll say Perry sues David for negligence and wants $100,000 in damages. The jury decides that David is 99% responsible for the accident. But Perry is 1% responsible too. The jury concludes that Perry was also careless. Playing a video game while crossing a street was contributory negligence. And our traditional contributory negligence rule is that Perry gets nothing. Most states in the U.S. no longer apply traditional contributory negligence.